Welcome everyone, welcome to my channel, and today we're going to talk about evidence, and this is week 5. We'll focus on witness and impeachment. The big picture, what are we going to talk about today? So in today's mini lecture, we're going to talk about Article 6, witnesses, and give us some tools to how to present testimony, and also to either impeach or repair the witnesses' credibility. And regarding Article 7, we will talk about the layperson's or experts' opinions. So competency and disqualification. How do we decide whether a witness is qualified? So we have a Hawaii rule here, HRE 6031.1. So this is a unique Hawaii rule. And it is regulating that if a witness cannot be understood, or the witness cannot understanding his or her duty to tell the truth, and the witness is disqualified. So the other rules are very identical with the federal rules. Next, jurors as witnesses. Jurors cannot be witnesses because the jurors don't testify in their own trial. A juror cannot testify before the trial in the case they are serving on. It is the regulation of HRE 606 and FRE 606A. And also we have the 606B, no impeachment rule. We cannot impeach a juror under OOE except OOE. The first O means outside information, and then the second O means outside influence, and then the last E is entry error. So that means if there's no outside information, it's improper, and there's no influence to the witness, to the juror, and if there's no entry error, so we cannot impeach a juror. And everything else about jurors' thought, emotions is off limits. The next slide, we're going to talk about the direct and cross examination. And for the direct examination, it can be some open question to build the witness credibility. For cross examination, so on the other hand, we're going to create some doubt about the witness's credibility. And regarding how to assist the witness, we have the LRR protocol. So those rules and those methods can help the witnesses to recall the event or some info. L is for lead. So we might the attorney might ask some leading questions, such as, weren't you at the Halloween party on October 31st? And refresh means the attorney can bring up some information or some material to remind the witness's memory, such as writing, photo, post, smell. And then the third one will be the recorded recollection. This one, usually it is not allowed unless the record concerns a matter the witness once knew, and the record was made when the witness's memory was still fresh, and then the recorded data was accurate. And also, it only allows, like I just mentioned, if the witness cannot recall well enough. So those will be the LRR rules for assisting the witness to recall the information and evidence. So for the next section, we're going to talk about how to impeach a witness. So regarding impeachment, so we are following the rule 613. The impeachment is applicable when there are differences between the prior trial statements and the trial's testimony. That will be under 613. The procedure will be, you should give the witness an opportunity to explain and deny. And after that, you might use some extrinsic outside evidence to prove the witness credibility or lacking credibility. For example, if the witness told investigators light was red, but now in the testimony the witness said it was green. In the cross-examination in under 613, if they deny, you can call the investigator extrinsic if the judge allows. So the toolbox B regarding impeachment, that will be character for untruthfulness. The general rule is the rule 404, but there is an exception for a witness's truthfulness. So keep in mind about the rule 608A. You may use opinion, reputation, testimony about witness untruthful character, but after credibility has been attacked, and any time for attack. And foundation for a character witness, you can show the basis, for example, like the knowledge, interaction, or knowledge of reputation in relevant community. Very special requirement under 60BB. So on cross-examination, you might inquire into specific instances of conduct probative of truthfulness, but you cannot use intrinsic evidence to prove the act. If the witness told you and explained the information, you are stuck with the answer. Impeachment C, prior convictions under 609. If the prior conviction is a felony, and then the witness was punished more than 1 year, so it is admissible only if probative value outweighs prejudice. If the crimes involve dishonesty and false statements, and this evidence is omitted automatically. And if the commitment of the crime is over 10 years, and it will require advance notice. Unless it is substantially outweigh the prejudice, it is not going to be admissible. And pardon and rehabilitation may bar use. And juvenile adjudications will never against the accused. But it can be limited use against the other witnesses. And defendant who doesn't testify, you cannot impeach the defendant. And the limiting instruction under FRE 105. And it is asking the judge to tell the jury the conviction is for credibility purpose, but not for propensity. So after talking about the impeachment, starting from here, we're going to talk about the strategy. There's some strategy can be used regarding credibility. For example, if the attorney identify the witness, there's a weakness in this argument, and then the attorney can bring it out on direct with context explanation to neutralize before cross-examination. And if there are some credibility attacks, and the strategies could be narration, can they tell it coherently? And perception, could they really see or hear? And memory, is the memory complete or accurate? And sincerity, whether the witness has the truthfulness, bias, or interest. So here will be the quick summary between the Hawaii and federal rules regarding the impeachment and witness. So Hawaii Rule 603.1, a formal disqualification for inability to be understood or to grasp truth-telling duty. For the federal rule 606, we have 606 and the Hawaii Rule 606. They have the core idea: no juror testimony about deliberations, with the OOE exceptions. Okay, so now we have a rapid exam checklist to see whether you understand these rules well enough. The first one, juror evidence. We first will apply 606B, and only OOE gets in. Witness can't remember, so we use LRR to remind them. And prior inconsistent statement, we need to use 613. And character impeachment, the rule is 60BA and 60BB. And conviction, 609A1 regarding felonies, and 609A2 regarding dishonesty, and 609B, there's a 10-year hurdle, and 105 limiting instruction. So those are the rules were covered in this week's learning. Okay, here will be some quick hypo. We're going to apply the rules for each scenario. The first one, juror affidavit says, we misunderstood the burden of proof. If that's the case, this evidence will be excluded because there's no OOE. It is not outside information, it is not outside influence, and it is not error entry. So it will be excluded. The next one, juror says, deputy told us defendant failed a polygraph. So this one will be omitted because it can be omitted to challenge the verdict. It is outside influence. Number 3, witness forgets where she was on October 31st. The attorney can ask a leading question, were you at the Halloween party? Or use the refreshment, for example, like an Instagram post. If the witness cannot recall, so probably we can use the recorded collection. Number 4, cross-ask witness about lying on a mortgage application. Witness denies. Permissible question under 60BB, but you cannot use extrinsic proof if they deny. Number 5, civil witness has a 12-year-old felony theft conviction. So you cannot bring this up to challenge the witness credibility. If you have to do that, there are a procedure you need to do. First of all, you need to provide notice. Also, you need to prove there is a probative value substantially outweighing the prejudice, but it is super rare. Okay, so summary of this course. So first of all, we talk about competency. In what situation we can allow a witness to testify, to testify in the court. And then the second one, jurors requirement. Under 606B, and only OOE breaks through. And stalled witness, so if the witness cannot remember something, we can use LRR to remind them. And impeachment, we can use impeachment rule 613, 608, 609, and with 105 limiting instructions. But keep in mind, always follow 3 check for unfair prejudice versus probative value. Okay, I hope you like this lecture and for the week 5 evidence course. I will see you in the next class.